many years ago when I was a staffer in the city council, before we moved ICE out of Rikers, I had an incident that was very personal. I had a neighbor of mine whose son turned 18 years old. She brought him here when he was 3 years old. He was not a documented citizen. He was a good kid, went to school. He gets picked up for a murder. He's a suspect in a murder case. He goes to Rikers Island. They realized a couple of months later that the kid was not involved in any incident. He was not the person. He wasn't there. He wasn't affiliated with anyone. And so they release him. And they release him to ICE. He didn't commit a crime. And so we need to be very clear that when we are fighting, we're saying if a person has not been convicted of a crime, they are not therefore a criminal, under quotes. And that's the concern, is that people will get swept up because they're simply at Rikers at the time. Not that they committed a crime that they were convicted of. So let's just get that very, very clear, because I keep hearing it over and over again, and it really, really bothers me. There's a distinction between, having been committed and not. My question, however, is on the DNA. According to media reports, the NYPD's DNA database contains as many as 82,473 genetic profiles, including samples obtained from children. Why is the DNA database not listed in the report, and how does the NYPD obtain DNA samples? Right.
So you mean why is it not in the IUPs?
Yes.
Because it's the OCME's database. It's not ours. It's an OCME database. So it's not an oversight or anything. It's because it's maintained by OCME and not by the NYPD. It doesn't fall within the scope of the Post Act.
Okay.
And then in terms of the data, I also don't have the data here. I can't really speak to the data you were citing
regarding the
numbers. I just don't have that.
Okay,
here with
but do you know how the NYPD goes about obtaining DNA samples?
I mean, there are various ways we do that. Sometimes it can be by consent. Sometimes it can be an abandonment sample. Sometimes it can be by court order. Those, I guess, are the three ways.
The abandoned property.
Right, so an abandonment can be in a variety of contexts. It could be, sometimes it can be abandoned, frankly, at a crime scene, right? That there are times when at a crime scene, we'll be able to identify something that may have DNA, and then it does have DNA. That could be an incredibly valuable investigative tool. There also could be an abandonment sample where someone is at a precinct and leaves behind DNA in a cup, for example, and then that can be used to get potentially a DNA exemplar. So I would say, consent, abandonment, court order. Those are the three basic categories.
What is it really abandonment if I don't know that I'm abandoning it and you're going to collect it for DNA? I mean, do you disclose that information to folks?
No, and I think the idea of abandonment, I think you can abandon something without knowing you're abandoning it. Sure, the person who unintentionally the person who unintentionally leaves evidence behind at a crime scene, for example. Right?
That's fair game.
That's fair game.
Yes.
Right. Someone does that in the precinct. Legally, that's fair game too.
Well, I don't think so, because if I'm hanging out with, let's say, Natasha here, Natasha commits a crime, and now I'm brought in for interrogation, and I happen to have a cup of coffee, and I leave my cup of coffee there, I didn't commit a crime. You don't have any evidence that I committed a crime, because otherwise you would have arrested me. Why would I not know that you would be collecting my DNA? Why would my DNA be in any type of database?
Well, I want to be clear. The fact, the scenario you're describing, where someone is coming in, you just happen to be at that place, you're a witness, whatever it may be. The idea that we're just surreptitiously taking your DNA, that's not my understanding of what happens at all.
Okay, so that's what I want to understand.
But what about a different scenario in which you're a suspect?
Yes.
You're not a witness to the crime. Yes. You're a suspect to the crime. Yes. You've come in to talk to the NYPD. You're talking to us. Yes. You then leave your DNA behind in something you ate or you drank, whatever. In that scenario, I understand the policy considerations that you're talking about. I get it. I do. But just as a legal matter, right?
I don't have a problem with you collecting the DNA. Yeah. It's the way that you collect the DNA that I have the problem with. Because if the person is a suspect in a crime, you have every right to investigate and do what you have to do. But why couldn't you get a warrant, get a court permission to obtain the DNA sample. Why, because to me it's very misleading. And it almost seems like entrapment. And God knows how many people are on that database that have committed no crime or haven't been found guilty of committing any crime.
So just as a legal matter, I don't think it's not entrapment. I think certainly, look, there are situations where we go get court orders for DNA.
Yes.
There also are situations where we could be investigating an incredibly serious crime. We don't yet have enough to get a warrant, right? But we have an opportunity because someone, in whatever context, left DNA behind, and that may be the linchpin in being able to charge that person or exonerate that person. Right? It cuts both ways. Right? The DNA may be incredibly powerful proof that someone is guilty. It also may be incredibly powerful proof that someone is innocent. And we have examples of both of those, I think. So I understand what you're saying, of course, and I understand kind of the sort of policy questions. I do think what I'm describing is legally permissible and appropriate.
Yeah. Deputy Speaker, I just wanted to add one thing, right? You're talking about the local DNA database, just something I discovered recently when we were talking about this, and I'm going to double check the exact number, but 60 to 70%, I think it's actually a little higher than 70%, already have a conviction and their DNA has been collected pursuant to state law and is in the state database already.
Okay.
Already. Because you said God knows how many people are on that who never did nothing. I hear you.
So we know it's a potential 30% of the 82,000.
Well, all I'm saying is they've already been convicted under and are on the state database. That's all I know. Okay?
Okay. Yeah, I know that we have an upcoming hearing on this, so I hope that you come prepared with all of the data. And thank you.